Good morning, Mr. Pritchett. It is the start of the trial. We've got our jurors, and they are about to come in. I wanted to check with you this Tuesday morning to see if you had had a change of heart and wanted to engage meaningfully, constructively, and non-disruptively and participate in your trial. Any update from you?
I'm not here to say I'm here improper dishonest jurors under the threat of arrest and coercion. I am not here in the legal name or legal person Max Christian that the state in this court has against my presumption of innocence presumed me and forced me to be. I am here in my private God-given Christian name, which I do not consent to being used for any commercial purposes in this courtroom. Furthermore, that the record show I do not understand the nature and cause of the proceedings and claims against me, nor do I understand the nature and authority of this court. How can I possibly understand these things and participate properly in this trial when the court has failed to disclose what jurisdiction they are operating under? The court has arbitrarily assumed personal jurisdiction over me by forcing me to be the legal name and person Max Christian when there has been no evidence proving such claim that I own that name or ever consented to that name on record. The court has denied my presumption of innocence in regard to those elements of the charges. The court has also prejudiced me by declining my request for full disclosure of a discovery that showed the evidence proving all the elements of the claim and charges against me, so I can prepare a proper defense.
Okay, Mr. Pritchett, Mr. Pritchett, I'm going to stop you because everyone in here has heard this now a bunch of times. Nope, you.
For this violation of the right.
Tell me how much more you have, because if you've got 30 seconds or less, you can. Otherwise, you continue to disrupt these proceedings by repeating baseless allegations about lack of personal jurisdiction and these things about improperio personam. And you've made a record of that a whole bunch of times. We don't need to remake the record. But if you want to spend the next 30 seconds adding what you want to add, then I've got a couple questions for you. If you want to answer them, great. If you don't, then we'll check in with you during the morning break.
Let the record show that the court has stated I can only see the full discovery only if I have an attorney. The judge of this court has practiced law from the bench by entering pleas on my behalf against my consent. I have been greatly injured by this court and stated I cannot properly participate and prepare a proper defense in light of these due process violations and the impartiality shown toward me. Mr. McBurney, are you prepared to rectify these issues and help me understand the full nature and quality of claims and charges against me, along with the nature and authority of the court? If not, can you recuse yourself on the fact that your impartiality and bias toward me have been brought into question?
All right, thank you, Mr. Pritchett. I think that it's important that the record reflect that the issues that are being prosecuted in this case are things with which you're most familiar, since you represented yourself at your revocation hearing in your other felony case, and the basis for your revocation in that case were the facts and circumstances of this case. So I am confident that you're familiar with the allegations. We've already discussed that. And when you were represented by counsel, you had full access to all the discovery, including discovery that you may not possess as an inmate at the county jail. When we had our discussion about you representing yourself, okay, well, we have differing perspectives on that. Regardless, this is an opportunity for you to join the proceedings. Do you care to sit?
How can I possibly participate properly if I don't have the evidence of all the evidence against me? You're not allowing me the opportunity to even understand the full nature of the cause and the authority of this court.
Well, I am, by inviting you to join us for these proceedings, but you're declining. You don't want to sit, and you don't want to engage in the way that someone who is meaningfully participating in the trial would engage. So I find once again that because you're unwilling to follow the basic rules of decorum in the courtroom, that I'm going to excuse you. I'll bring you back out in the next break. And if you want to participate, you remain welcome to do so as your own advocate, which is what you requested last week and is what I granted you. So, Deputy, if you would remove Mr. Pritchett from the courtroom, we will try again later this morning.
I think it's better. It's a good call.
We're back on the record in State versus Robinson and Pritchett. Mr. Pritchett has been brought back into court. Two things for you, Mr. Pritchett. There is an exhibit list from the state, and then some family member of yours brought a document that she said you wanted. So that's the second piece of paper. I want to make sure you add those to your collection. And I want to know again if you would like to join us and participate. And yes, you're on the record.
This is all discovery.
I've given you an exhibit list and a document that a family member of yours wanted you to have.
On the record, Mr. McBride, before you were a judge, you were a lawyer. Before you officially became a lawyer, you signed a title of nobility. How can this court lawfully move forward if you're not even supposed to be on the bench? And according to the Constitution, you are no longer a U.S. citizen.
That's an interesting question. I didn't know I had a title of nobility. Maybe because of that, I could retire early. But for now, I'm going to stick with the title of judge and ask you if you'd like to sit or if you'd like to go back to lockup again, and we'll check during the lunch break if you want to rejoin us.
I will sit down, actually. I just have to understand what jurisdiction is for operating on.
The jurisdiction of the laws and the Constitution of Georgia and the United States. So what's going to happen, should you choose to sit down, is the jurors are going to come out. I am going to swear them in and give them some basic legal instructions, and then it will be time for folks to give opening statements. You will have an opportunity to give an opening statement if that's what you want to do. When it's your turn, I will address you. It would be real helpful if you would tell me the manner in which you would like me to address you so that I don't get you upset by using a title or a name that for purposes of this proceeding you seem not to like. Are you prepared to answer that for me?
Yes. Can this court first take judicial notice that I am not the legal name of the legal person Max Pritchett?
I cannot take judicial notice of that, but I would love to know, I'm going to write it down, how you would like me to address you when we've got the jury in here.
Why can't judicial notice be taken?
Because that's not the type of thing for which judicial notice can be taken. Judicial notice can be taken of records in the court's docket, of non-arguable things like today is Tuesday, or when the sun rises, the sun sets, things that are incontrovertible.
That's an arguable claim that I am the legal name person Max Pritchett.
That's not what you asked me to take judicial notice of. Why don't you repeat that?
You said that the court couldn't take judicial notice of it because basically it's an arguable thing, and it's not an incontrovertible thing.
I thought you asked me to take judicial notice of the fact that you don't go by the name Max Pritchett.
That I'm not a legal person, Max Pritchett.
Right, and that's not something I can take judicial notice of.
That's a fact, and it is an incontrovertible thing. Why can't you take judicial notice?
All right, you've got 3 seconds to take a seat. If you choose not to take a seat, we're done this time of the merry-go-round, and we'll have you go back to lockup. You're going to take a seat?
Just before I take a seat, just to clarify, because you are going to claim the evidence of why you're claiming to be a legal person, Max Pritchett. I'm going to clarify jurisdiction. You said this was jurisdiction of the state of Georgia. I just have to make sure clarify some things that the Constitution speaks of 3 jurisdictions in your state, which are common law, equity, and morality. Which of these jurisdictions will operate?
We're done with that conversation. Do you want to give me a name or title you'd like me to use?
So this jurisdiction is not constitutional. Is that what you're saying?
Mr. Pritchett, take a seat, please, or I'm going to ask the deputy to send you back to lockup. Okay, if you take him back, please. Because you didn't give me a different name to use.
Because you're still recognizing me. If I give you a different name, court is still recognizing me as something that is not.
This is a great opportunity to take a seat. Going once.
I'm still trying to understand the jurisdiction of this court.
Okay, well, I'm gonna give you an opportunity to think more about it back in lockup, and we'll check in with you at lunchtime.
The court labeling me as disruptive because I'm not taking claim to something that they're forcing me to.
No, I'm labeling you as disruptive because you won't sit and you won't tell me by what name you'd like to go. Good afternoon, sir. We are on the record, and I wanted to chat with you again to see if you have decided that you want to join the proceedings. Are you prepared to take a seat and let me know by what name you'd like me to refer to you when I introduce you to the jurors?
I'll sit down. No, at no point do I waive any of my rights. I'll take a seat.
Okay. I'm not asking you to waive anything at all. As you know, my default has been to refer to you as Mr. Pritchett. That's how you've been introduced to the jurors in terms of a name. Is there a different name or title you'd like me to use when I'm turning to you? For example, with this next witness, Officer Weems, when she's testifying, the state's going to ask her some questions. Ms. Mignot may ask some questions on behalf of Mr. Robinson, and then you'll be entitled to ask questions if you want to. You're waiving nothing, and you're obligated to do nothing at all. But at some point, I'll turn to you, and I need for the record to say, Mr., and I plan to say Mr. Pritchett, but I don't want to say that in a way that causes you to become agitated or frustrated or feeling like somehow your rights are being compromised. So again, my default will be to refer to you as Mr. Pritchett unless you tell me now by which name or title you'd like to go.
You can refer to me as the accused.
Okay. I think I can make that work. If it becomes unwieldy, then I'm going to ask you for a substitute. Okay?
You know that by default you made a mistake and I'm referring to me as Mr. Pritchett.
Nope. When you are given an opportunity to address the jury, which you'd have in your closing argument, because you elected not to be here during opening statements, you can talk to the jury about your theories and views of names and identities and all that. But so you're not surprised or confused, I'm going to explain to the jury that Mr. Pritchett has decided to join us, and he has asked that I refer to him as the accused from here on out, and then that's what I'll do. Okay?
Can you just refer to me as the accused and leave the Mr. Pritchett part out? That is not something I ever went by.
Okay, and you'll be given an opportunity at the appropriate time to share with the jury your claim that you've never gone by the name of Max Pritchett. But I've told you how it's going to play out. I have to explain to the jury who this gentleman who is appearing in the middle of trial is, and then I'm going to explain that you've asked to be referred to as the accused, and from that point forward, that's exactly what I'll do.
You should let them know that I believe that there has been a mistake as far as the court referring to me as that legal name.
I'll fashion something along those lines. Okay. All right. Let's bring the jury in, please.
How do we go about this?
You say whatever you want to say. This is your chance. It's a little different from Mr. Robinson because you're your own advocate. And so you don't have to say anything at all. This is your time to allocute, to say, here's what I think you should do, and here's why. But you're not under any obligation to say anything. If there are things you want to share, now is the time, but you don't have to do anything.
One scripture that comes to mind is in James, and it's that mercy triumphs over judgment. And I believe, God, according to his word, desires repentance over punishment. And
believe in this day and age, 2024, we do have to look at reality for what it is. And the prison system doesn't save, but I do believe that every life is worth saving, including mine. But again, everybody's life is worth saving. And I say that to say that state's recommendation of that time is not saving my life, but it is more. It is definitely more destroying it. And I just firmly believe that even over the course of these 4.5, 5 years that I have already been incarcerated, it wasn't the bad conditions that I'm surrounded by. It wasn't the stabbing and the suicidal that I'm surrounded by. It was none of these things that caused me to look, at myself and create a deeper change within me. It was none of those things that caused me to do that. I believe it was me crying out and searching for God Himself that really caused me to do it. I'm not sure exactly why. It took this for me to really search and cry out for God in a genuine, full hearted, wholehearted way. Um, but I know sometimes it does take those drastic measures for a person to really, build that relationship with God and their Creator, which I believe is everyone's duty on this earth, and everyone's duty is also to fear God and follow His commandments. And again, I believe that, like I said, over these past 5 years, I have raised my standard of just morale and value and and knowledge, because the word repentance, it actually means, when you break it down, it means to gain a new understanding and and to gain new knowledge. And I believe I've gained a new level of these things to to really allow me to be aware, fully aware of the decisions that I make. Um, and this is an awareness that I was lacking previously, of course. But over these past 5 years, I believe that there's been just like in me a new level of change, a new level of virtue and standard of just morale again that I've reached. And going to prison for the rest of my life would put me in fear of just, degrading myself back down to a level that I never want to go back to again. You know, I only want to get closer to God. I don't want to stray from Him. And I believe that just being in prison again for the rest of my life put me in danger of really straying and going away from God. And so again, I am asking for the court to allow its mercy to try and triumph over His judgment. Um, to also taking into account that I do already have a 20-year sentence. Um, and acknowledging that, I would ask the court for 20 years in concurring with the sentence I already have. Um, but of course, in asking that, I would also just ask them to, and it may be hard, but I would also ask them to believe that within that time period, um, there will be a level of elevation spiritually and mentally that I will achieve, to where again, I won't stray from the commandments. I won't stray from God. Um, every life is worth saving, and I believe right now with the request, um, I'm imposing a method that this court can possibly save my life rather than destroy it. I believe the plan imposed by the state is just destroying my life. And again, every life is worth saving. And it wasn't, like I said, it wasn't the conditions or the environment I've been in prison and in jail these years that it caused me to, look within myself. It was the Spirit of God Himself that caused me to do that. And I don't want to lose that. I don't want to be in a position where I lose that, ability to elevate. And so, yes, I just ask for grace and mercy.
All right. Thank you, Mr. Pritchett. I always prefer salvation over punishment. This is the worst part of the job of being a judge. I have excellent advocates in front of me that are pulling not in entirely different directions. No one's saying let everyone out right now and rejoice their sentence is over. But I wanted to be clear that part of what necessarily flows from a jury finding defendants guilty of multiple armed robberies and aggravated assaults where people were left praying for their lives, seeing their lives flash before them, not sure whether they'd live to see the next day, are pretty meaningful consequences. This case is very different from a shoplifting or an entering auto. There are 7 people who will never forget what happened to them, and what happened to them was in no way a good thing. And that is what drives this, not some refusal on my part or the system's part to appreciate that the lives of those who were accused and convicted in this case were complicated leading up to these events. Mr. Pritchett, you and your father and your sister all asked for mercy. Mercy certainly flows most readily to those who showed mercy themselves. And I'll tell you, the part that I struggle with the most is that within a few months of you being involved, and I'll agree with you, it was involved very peripherally with the first home invasion burglary in which someone died, you were back in the mix. I appreciate that you were younger, but what I have heard from your father and your sister is that, unlike Mr. Robinson, you were blessed with a situation, a childhood where you weren't struggling with mental health challenges, got to college, and were afforded any number of opportunities. I wouldn't be surprised if you tested off the charts with IQ. You strike me as an exceedingly intelligent person. I watched you absorb the way the lawyers were doing what they did in court, and you fairly quickly were able to do the same. And so I'm left puzzled at how you ended up doing the things that you did, because they are very, very inconsistent with what your sister experienced. And while she called you her hero, I'm confident you're not her hero as the Jose Greer case or by being involved in this case and what you did on November 8th. But as I said, everyone is a composite of things. And I think that you've let your family down by not once but twice getting involved with real dangerous, violent criminal activity. I'm not sure how to eliminate the virus from Mr. Pritchett's hard drive. One would think that losing his brother to gun violence might do it. One would hope that if that didn't, then the mercy that Judge Dempsey showed would have had an impact. But that was one persistent virus, because just a few months after getting out from Judge Dempsey's merciful second chance sentence, this happened. And I think I would be remiss and be underserving society if I said, well, let's have a third chance and get you right back out. You may have grown up at the altar, but you have strayed very far from it. And I'm happy for you if you have refound a spiritual way of life, and you are a charismatic person. Change starts with you, but you may be able to affect change on others while you are in custody. I hope you find that within you. Your sentence, Mr. Pritchett, as to count 1 is 20 years to serve. Counts 2 and 3 are 20 years to serve. They run concurrently with count 1. Counts 6 and 7 are 20 years to serve. They run concurrently with count 1. There's no sentence for counts 4, 5, or 8. You were found not guilty. Count 9 merges into count 2. Your sentence as to count 10 is 15 years to serve 10. That runs consecutive to count 1. Count 11 is 15 years to serve 10, concurrent with 10. 12 merges to 6. 13 merges to 7. Count 14 is 15 years to serve 10, concurrent with 10. 15 merges with 3. Count 16, the aggravated battery, is 15 years to serve 10. That merges, that runs concurrently with count 10. Count 17 was a directed verdict. 18 is 5 years to serve, concurrent with count 1. 20 is 5 years to serve, concurrent with count 1. And then 19 has to run consecutive to 10. It is 5 years. It is probated. That should add up to a 40 years to serve 30, partially parolable prison sentence.
Well, guys, we've come to the end of this proceeding, and honestly, with consequences this serious, you would have expected Mr. Pritchett to walk into trial with a little more humility, but he didn't. As we saw, he had to be removed multiple times before the jurors were even brought in, and the trial could move forward. In the end, the verdict was guilty, and when the judge gave him a chance to speak, some of the things he said really stood out. He talked about how the possibility of life in prison wasn't helping him yet earlier. He had been focused on a 20-year sentence. And remember, that 20 years had already been offered to him in a previous appearance. If he had been honest with himself, stopped playing games, and taken accountability, he could have accepted that deal. Instead, he rejected it, disrupted court, and only after being found guilty did everything suddenly become real, and that's when he started asking for mercy. What's interesting is that he's clearly an intelligent young man. We learned he's been to college, and even the judge pointed out that you can hear that intelligence when he speaks. But unfortunately, intelligence alone isn't enough if you choose the wrong path or the wrong people to follow. He also talked about finding God, and from my perspective, faith isn't something you use as a last-minute strategy to escape consequences. Belief doesn't mean instant perfection, but it also doesn't mean using God's name to bargain your way out of a situation. And when he suggested that receiving a life sentence or a harsher punishment might push him back toward the behavior he's trying to avoid, that doesn't really sound like someone whose life has truly been transformed. In the end, he received about 35 years, roughly, 15 more than what he could have had if he'd accepted responsibility earlier. I also want to give a shout out to Judge McBurney. This was my first time hearing him handle a case like this, and he managed every appearance and the entire trial with professionalism and clarity. Even when Mr. Pritchett tried to bring spiritual arguments into the courtroom, the judge handled it thoughtfully and respectfully. Out of all the judges I've seen deal with these kinds of situations, he may be one of the most composed and effective so far. Hopefully, Max Pritchett really does take this time to reflect, grow, and get his life together, so that when he eventually gets out, he makes better choices. It's unfortunate that a much lighter opportunity wasn't enough to teach the lesson, and that it took 35 years and stricter consequences for reality to set in. But sometimes, that's just how it goes. Thank you guys for sticking with me through these long proceedings and trial coverage. We couldn't show the entire trial here, but if I'm able to upload the full version separately, I will. As always, I appreciate you all for watching, subscribing, commenting, and supporting the channel. For now, guys, God bless. God bless.